to this issue, and in 2014 the government of Malta acted on this and appointed Her Excellency Mary Louise Coleiro Preca as President of the Republic. Her Excellency Ms. Coleiro Preca is the second woman to serve as President in Malta in Malta's 50 years of independence. It is also worth noting that 4 out of 6 members of the European Parliament elected in the recent round of European elections were women, indicated that government's proactive approach, as well as greater equality awareness among the general public, are permitting greater inclusion of women in public life. Mr. Chair, Malta has always taken a strong commitment towards protecting the rights of those that are at risk of vulnerability, including persons with disability, ensuring that all socially or culturally constructed barriers are overcome and a strong legislation is made available to ensure the protection and consolidation of human rights for persons with disabilities is one of the commitments that the government is continuously undertaking. As a matter of fact, Malta is working hard together with the local stakeholders to ensure that the social policies in the realm of disability address the specific needs of persons with disability. The Government of Malta has shown its commitment towards disability by setting up Parliamentary Secretary for Disability Rights and Active Aging to monitor the specific needs of this impaired group. Moreover, the Maltese government enacted new legislation that protects persons with disability. The Guardianship Act, for instance, provides for the appointment of a guardian to help persons in need by safeguarding their personal well-being and property, and who will be able to act in his or her stead. The government is also currently drafting an Adult Protection Act and strengthening the Equal Opportunities Act in close consultation with the Federation of Organizations for Persons with Disability and the National Commission for Persons with Disability. A scheme has also been set up to encourage local councils to develop infrastructural projects that will ensure our communities are accessible and open to all the citizens. In addition to the changes being carried out at government level, the Parliamentary Secretary for Disability Rights and Active Aging is looking at strengthening the role of the NGOs by sharing responsibilities and increasing the involvement of NGOs in delivery of services provided by both the state and the private sector. Work is currently being undertaken to review the current standard system to see how this can be overhauled to best suit the individual and focused needs of persons with disability. Malta will also strengthen its policy framework through the launch of Malta's first national disability policy in the coming months. This will then be followed by a national disability strategy in line with the Convention on the Rights of the Persons with Disability. In line with Article 33 of the Convention, a focal point manager was appointed in April 2014. Malta is looking at a variety of initiatives to bridge back to the community, review policies, services and legislation, set up new organizational infrastructure that will allow the government, via the Parliamentary Secretary for Active Aging and Disability Rights, to monitor what persons with a disability and their families have to say and are feeling, thus ensuring that a comprehensive reaction to this minority demands are made. Mr. Chair, I would like to address specifically Article 6, subparagraph 1 of the ICCPR, recognizing every human being's ability, recognizing every human being's inherent right to life, as this is a fundamental value for Malta. Malta continues to sustain that the right to life extends to the unborn child. The right to life is enshrined in the Constitution of Malta. Malta believes that human life begins at conception and therefore considers that the termination of pregnancy through procedures of induced abortion at any stage of gestation and for whatever reason is an infringement of this right. Malta therefore cannot recognize abortion or any other form of termination of pregnancy as a legitimate measure of family planning. Malta is also committed to the promotion of sexual and reproductive health and to the protection of the right of women to have control over and decide freely and responsibly on matters related to their sexuality and the timing, number, and spacing of children free of coercion, discrimination, and violence. In this respect, Malta recognizes the importance of the dissemination of knowledge, including information on safe and effective methods of family planning, to enable women and young girls to make informed and responsible decisions on matters relating to their sexual and reproductive health. Malta offers quality health care before, during, and after pregnancy, including the emergency obstetric care, which is easily accessible and free of charge to all entitled persons. On a national level, the government, through its National Healthcare Service, has continued to strengthen its fight against STDs and other medical issues through strengthening the dedicated genitourinary clinic that serves the sexual and reproductive health needs of the whole population through specialized medical attention as required and with full confidentiality to patients of any age. In fact, a number of sexual and reproductive health care services are freely available within the national public healthcare system. These include family planning, safe motherhood, infertility treatment, assisted reproduction, prevention, confidential testing, diagnosis and treatment of reproductive tract infections, STIs and HIV/AIDS, prevention and treatment of reproductive cancer and maternal morbidities. Mr. Chair, under Maltese law, children's rights are essential to the proper development of a child and therefore considered to be non-negotiable. Children are considered as individuals entitled to inalienable rights, like all others. Malta is continually keeping children high on its agenda. Indeed, Act 3 of 2014 introduced legal amendments to the Criminal Code regarding the protection of children. The first amendment concerned the minimum age of criminal responsibility, where this has now increased from 9 to 14 years of age. The second recent amendment in the Criminal Code concerns the abolishment of corporal punishment. These two legal amendments introduced by Malta are seen as a very positive step towards further securing and guaranteeing the rights of children as well as fulfilling Malta's international obligations. Mr. Chair, in 2014, the Government of Malta had held a public consultation on the process of establishing a national human rights institution under the working title of a Human Rights and Equality Commission. The aim of this public consultation was to collect input from the general public, civil society organizations, trade unions, business organizations, political parties, governmental institutions, and all others that would like to contribute towards this process. Subsequently, the Ministry for Social Dialogue, Consumer Affairs and Civil Liberties started a process of international consultation with the European Network of Equality Bodies, the European Network of National Human Rights Institutions, the European Union Fundamental Rights Agency, various national human rights institutions and equality bodies, and relevant departments at the University of Malta. The National Commission for Promotion of Equality as well as the Ombudsman also provided their input. The aim of the government is to have the National Human Rights Institution, which will be an independent body, in conformity both with the United Nations model of national human rights institutions laid out in the Paris Principles, as well as the European Union's equality body model laid out in EU equality directives. Following a new round of consultation, a bill will be drafted and presented in Parliament for discussion in due course. Mr. Chair, I would be remiss if I did not dedicate some time to one of the biggest challenges Malta has been facing for the last 10 years. As has been widely reported in the media, Malta has experienced heavy influxes of irregular migration from North Africa since 2002. Ever since then, the number of arrivals of irregular migrants remained constantly high. The asylum recognition rate in Malta has consistently exceeded 50% over the past years in view of the situation in the countries from which these asylum seekers originate, particularly from the Horn of Africa. In June 2013, the remaining legislative instruments, which including revision of the Asylum Procedures Directive, the Reception Conditions Directive, the Qualifications Directive, the Dublin Regulation, and the Eurodac Regulation, were adopted in order to establish the Common European Asylum System, the CEAS. The CEAS aims to ensure high standards of protection for refugees and asylum seekers in order to reduce discrepancies among the member states. With regard to the procedures and rights afforded to asylum seekers and beneficiaries of international protection, to date, around 67,000 persons have been rescued by means of the Italian Operation Mare Nostrum, including over 6,500 unaccompanied children. These numbers are in themselves a clear testimony to the humanitarian crisis that we are witnessing unfolding in front of our very own eyes. The movement of such large numbers of people who are undertaking life-threatening journeys is resulting in an unacceptable high number of deaths at sea. As a country at the forefront of this tragedy, we are trying with all the possible means at our disposal to effectively address this problem. This is not just a Maltese problem, however. This is a global problem, and Malta on its own, with its limited size and resources, cannot be left to deal with the problem alone. In this respect, I am very pleased to know that both the International Organization for Migrants and the UNHCR have over the past months publicly highlighted Malta's plight and called for more solidarity to be shown towards countries at the forefront of the immigration wave. As a matter of fact, today, the International Organization of Migrants and UNHCR, under the auspices of the President of the Republic of Malta, have launched in Malta a joint report on the issue of unaccompanied migrants. The report contains recommendations which the government will study in great detail to look at ways how to address this issue. Mr. Chair, it should be noted that whilst Malta will be retaining its detention policy in respect of those who enter the country irregularly, reforms will be introduced with a view to comply with the Recast Reception Conditions Directive, which will be transposed into national legislation by July 2015 at the latest. Moreover, Malta will be amending its immigration legislation with a view to achieving full compliance with recent European Court of Human Rights judgments, including by way of introduction of provisions enabling those detained to challenge their detention as opposed to only the duration of detention, as well as through the introduction of reasons for which an asylum seeker may be detained, among other provisions. It is worth noting that some reforms are already being implemented, giving that regular reviews of those in detention are being conducted with a view to ensuring that no one is detained unnecessarily. Such reviews are carried out pursuant to the common standards and procedures for returning illegally staying third country national regulations. With regard to claims of poor conditions in detention centers, the difficulties Malta faced are due to large number of arrivals in relation to Malta's resources. Regular maintenance to improve the facilities of open and closed detention centers is conducted. Adequate food, clothing, cleaning materials, and so forth are also provided. Meals provided are inspected on a daily basis and replaced if not up to standard. The government also undertakes continuous efforts to assist potential asylum seekers through improved processing of applications and calls on the countries concerned to cooperate in the readmission of their own nationals who are not authorized to remain in Malta. Malta acknowledges the work done by the United Nations High Commissioner for Refugees to lead and coordinate international action to protect refugees and resolve refugee problems worldwide, in particular the efforts made by UNHCR in respect of Malta. Malta has always extended and will continue to extend its full assistance to asylum seekers and beneficiaries of international protection. Indeed, in September 2014, Malta welcomed the UN High Commissioner for Refugees, Antonio Guterres. Every possible effort is being made to improve reception conditions and to provide integration-oriented assistance. However, it is evident that Malta has very limited absorption capacity and resources. Mr. Chair, despite its size and limitations, Malta will continue to strive to comply with its international commitments and do its utmost not only to safeguard and advance human rights, but also with the aspiration of realizing them for all. The measures taken in the past 2 years by Malta attest to the commitment of the government to continuously modernize and improve life not only for the Maltese, but everyone living in our borders. The adherence to the ICCPR and other human rights treaties serves as an inspiration and guidance to achieve this goal. Thank you.
Thank you very much, Mr. Agius. And now I invite you or such colleague or colleagues as you decide to give the summary of the State Party's replies to the list of issues. You have the floor, sir.
Thank you. Mr. Chair, the following is a summary of the list of issues in relation to the second periodic report of Malta as raised by the Human Rights Committee. Some of the matters raised in this list of issues were already addressed in my opening statement. Mr. Chair, the provisions of the Constitution, the European Convention Act, and the judicial remedies available to all persons in Malta ensure that the rights enshrined in the Covenant, as contained in Maltese legislation, are fully enforceable. However, at present, Malta will be maintaining its reservations to the Covenant until their further examination is concluded. Malta affirms its commitment to give greater prominence to the area of human rights by launching a consultation process with local and international stakeholders with the goal of strengthening the current human rights and equality legislative framework and the setting up of a national human rights institution. The remit of the National Commission for the Promotion of Equality is intended to be widened to allow the Commission to become a Human Rights and Equality Commission acting as a national human rights institution, as well as an equality body in accordance with the provisions established by the Paris Principles and European directives on equal treatment respectively. Mr. Chair, Malta is continuously undertaking work in the area of non-discrimination and equal treatment between men and women. In June 2012, Chapter 456 of the Laws of Malta, the Equality for Men and Women Act, was amended to safeguard equal treatment on additional grounds, including religion or belief. Following Act 10 of 2014, the Constitution of Malta Amendment Act, the Constitution of Malta was amended in April 2014, where sexual orientation and gender identity were added to the list of prohibited grounds to the anti-discrimination provisions. Following the introduction of the pertinent legislation in the Criminal Code, concrete measures were also taken by the police authorities to combat manifestations of racism and xenophobia, including training and education to police officers. Training was also specifically directed towards police officers attending to border guard duties. Training for border guard is held every 18 to 24 months. Bill 53 of 2014 passed its first reading in Parliament. Bill 53 increases punishments by 1 to 2 degrees where the offense is aggravated or motivated on the grounds of gender, gender identity, sexual orientation, race, color, language, national or ethnic origin, citizenship, religion or belief, or political or other opinion. Though the National Action Plan Against Racism and Xenophobia has not yet been formally adopted, it is expected to inform the forthcoming human rights and equality strategy. Currently in Malta, all cases of reported offenses of racism and xenophobia, including racially motivated violence, are investigated immediately by the executive police, and if the offense results, offenders are arraigned before judicial authorities. With regard to bullying and harassment in schools in Malta, schools have the ethical and moral obligation to address and stop harassment incidents about which they know of or should have known, and provide equal protection for all students. Victims of harassment and discrimination are also equally supported. Within the personal, social and career development subject, the aspect of bullying is tackled within the primary and secondary sectors. Specific learning objectives focus on bullying related to different sexual orientations, color, race, religious denominations, and any other factors that one can be bullied about. In the higher forms, teachers deal specifically with learning objectives related to clarifying and helping students understand different sexual orientations or gender identities so that they learn to respect and accept sexual or gender difference, and thus helping to minimize intolerance and bullying. The aim is to continue encouraging schools to challenge existing beliefs and stereotypes and breaking assumptions, whilst integrating positive LGBTI role models as part of general ongoing life routines. Other specific measures are being introduced by the government to tackle problems faced by trans and intersex children. These include measures like introducing gender-neutral bathroom facilities, the opening of co-education schools, and girls are also being given the opportunity of choosing a gender-neutral school uniform. In addition, the Department of Psychosocial Teams is working closely with the child, the parents, the senior management teams, and teachers, as well as all the other children, to ensure integration and acceptance of the child, as well as to tackle possible bullying. In order to enhance the female participation in the labor market and public life in general, the Maltese government has introduced a system of free childcare. Mr. Chair, unfortunately, no country is immune to the human rights violations and problems that is the use of violence against women and children, including domestic violence. In Malta, the specialized court system is in place, which deals with cases of domestic violence, enables more consistency in the treatment of these cases. There is, in effect, increased sensitivity to the needs of the victims, who can be directed to other services. Dedicated courts or prosecution teams have now been able to process cases more quickly. Magistrates and prosecutors who consistently deal with domestic violence cases may see repeat offenders, with the result that they can build a more detailed background about the case and may better address the needs of the victims. Malta also ratified the Istanbul Convention in August 2014. A committee to explore the various legislative and policy requirements emanating out of the convention has been set up, and it should provide a number of suggestions in due course. In the meantime, Malta is committed to adopt a strategy to tackle gender-based and domestic violence, which would meet the four requirements above. That is, recording of statistics regarding the number of such cases, carrying out of investigations, imposition of sanctions, and provisions of remedies to victims. Mr. Chair, on the right to life, prohibition of torture and cruel, inhuman, and degrading treatment, right to liberty and security, and the treatment of persons deprived of their liberty, including conditions of detentions, rights of migrants, refugees, and asylum seekers, Malta will continue to respect its international obligations. In the replies to the list of issues, Malta provided the details and actions taken in relation to the cases that happened in Malta in 2008, 2010, 2011, 2012, and 2013. Furthermore, the Maltese government reiterates its position that persons rescued at sea are not subjected to Maltese jurisdiction, but have knowingly chosen to be rescued by the Maltese authorities rather than remain in a dangerous distress situation. This means Malta has always respected its obligations under international law. The fact that Malta honors such obligations should in no way be construed as Malta agreeing that further obligations ensue. The Maltese authorities have always complied with their international obligations, and fundamental rights have always been respected in the context of operations carried out by the Armed Forces of Malta. All reported cases of search and rescue were duly addressed by the Armed Forces of Malta in accordance with international law. Thousands of lives have been saved in the central Mediterranean as a result of these operations. In Malta, the principle of non-refoulement is safeguarded by the Refugee Act and related legislation. In practice, all irregular migrants are informed of their rights, including in particular the right to apply for international protection. Such information is provided by means of booklets as well as information sessions delivered by the Office of the Refugee Commissioner. Information is made available in the main languages of the countries of origin of asylum seekers. The detention of irregular migrants finds its legal basis in the Immigration Act. Pursuant to the decriminalization of illegal entry, irregular migrants are subject to administrative detention within centers which are distinct from the prison facilities and under separate management. It should be clarified that the vulnerable migrants, including unaccompanied migrants, persons with disability, the elderly, families with young children, pregnant women, and lactating mothers, are not detained. Their freedom is restricted only until their vulnerability has been established and the necessary medical clearance is given, with medical checks systematically carried out for every immigrant upon arrival. Vulnerable migrants are provided with alternative accommodation as well as any special attention they may require, such as particular health care. Minors receive the same rights as Maltese minors, including the right to attend state schools. It is therefore considered that adequate procedural safeguards are in place in order to ensure that the detention of irregular migrants does not infringe international standards. Unaccompanied migrants are protected with a care order under the Children and Young Persons Care Order Act. This implies that the Minister for Family and Social Solidarity has care and custody and ensures through an advisory board setup that a care plan for each and every minor is prepared and that unaccompanied minors are protected and cared for on a psychosocial level. It should be noted that Malta's detention policy is also fully compliant with recommendations of the Council of Europe, particularly Recommendation 2003 number 5, on the detention of asylum seekers. Notwithstanding, Malta is also transposing the EU's Recast Reception Conditions Directive into national law. The reforms introduced will serve as alternatives to detention will be referred to in national legislation in accordance with Article 8, subparagraph 4 of the directive with regard to, for example, regular reporting, and include legislation indicating reasons why asylum applicants may be detained as per Article 8, subparagraph 3 of the directive. Furthermore, within the existing legal framework, it is possible for the detainee to challenge detention before the Immigration Appeals Board, in accordance with the Immigration Act. Amendments are, however, to be effected to Article 25A, subparagraph 10 of the Immigration Act, whereby a challenge against a detention order may be filed at any point of the procedure. At present, it is possible to file an appeal against detention if it is deemed that the duration of such detention is unjustified. The sitting before the board are conducted in a similar manner to those held before the national courts. Individuals may be assigned a legal aid representative and evidence is heard by the board and submissions are made by the parties. The appellant is also given the opportunity to make oral and written submissions. It should also be noted that the members of the board enjoy security of tenure, with a view of ensuring the independence of the board. All asylum seekers whose application is being processed at first instance by the Office of the Refugee Commissioner have the right to access legal assistance at any stage of the procedure. Immigration detainees in Malta are not subjected to disciplinary sanctions and are allowed to receive regular visits from a large number of NGOs and ministers from various religions. Regular visits by lawyers for legal aid purposes are also allowed. Mr. Chair, as highlighted in the opening statement, Malta's position on abortion remains unchanged. I would like to hereby reiterate Malta's position on reproductive rights and its long-standing position that any recommendation or commitment should not in any way create an obligation on any party to consider abortion as a legitimate form of reproductive health rights, services, or commodities. With reference to the questions on reasonable chastisement, though Maltese law does not define any reasonable chastisement, it is left up to the Maltese court to interpret reasonable chastisement. Following a 2014 amendment to the Maltese Criminal Code, it was specified that reasonable chastisement cannot refer to corporal punishment. This amendment makes it very clear that the infliction of any kind of corporal punishment constitutes a crime against the person. This amendment applies also to corporal punishment in alternative care settings, in early childhood care, in schools, and in penal institutions. In order to further protect children who are deprived of a family environment, the Maltese Parliament is currently debating the Child Protection Act. This act, apart from establishing child court services and introduces child protection orders, provides for special care and protection for children removed from their parents and placed in out-of-home care. Moreover, the proposed act provides that where an interested party shows to the court that foster care has been ongoing for more than 4 years, care reviews and appears to be long-term, and the view and wishes of the child have been considered, it may decree permanent foster care. In considering the child's best interest, the court shall take into consideration the child's views and wishes in a manner that is appropriate to the child's maturity and understanding, and any particular needs to and the child's attachment to the natural family. Mr. Chair, government continued efforts in advancing anti-trafficking prevention efforts by publishing its first anti-trafficking national action plan in October 2011. Measures targeting the suppression of human trafficking in Malta continue to be implemented in the second National Action Plan on Combating Trafficking in Persons, 2013-2014. Various training events were held for stakeholders to continue raising awareness among public authorities on cases of human trafficking, as well as to register greater effectiveness in relation to the prosecution of cases and the identification of victims. Joint training sessions were held for professionals working in the field to encourage networking. Outcomes of the training included the development of a formalized victim referral mechanism and the drawing up of a list of national indicators. Operations within the police vice squad have been split into 3 specialized units to include a special unit focused on prostitution and human trafficking. It is considered that the concerted efforts in this unit assisted in improved identification of human trafficking cases and an increase in trafficking cases being investigated was witnessed, followed by an increase in the arraignment of suspected perpetrators in court. Mr. Chair, the reform of the justice system started in March 2014, following an evaluation of the final report by the Justice Reform Commission. The reform process is to be implemented over a 3-year period until 2016, and for the first tangible results to be reported upon at the end of 2014. The amendments to Article 35, subparagraph 1 of the Criminal Code and to Article 37, subparagraph 1 of the Criminal Code as well, increase the age of criminal responsibility of minors from 9 to 14 years. Hence, the Juvenile Act remains applicable to minors aged 16 and under. Furthermore, the inclusion of Article 534AB, subparagraph 1 of the Criminal Code, effective by means of Act 4 of 2014, amending legislative provisions that were considered as limiting the rights of persons deprived of liberty to have access to a lawyer. Mr. Chair, the adoption of the Civil Union Act has already been addressed in my opening statement. With regard to the question on freedom of expression, freedom of conscience, and religious beliefs, the Criminal Code of Malta provides for the said offences in no way detracts from the right of freedom of one's beliefs and freedom of expression as enshrined in the Constitution. Moreover, under Article 83b of the Criminal Code, this freedom is further protected in that if an offence is found to be motivated by the victim's religious belief. Mr. Chair, the above is a synopsis of the detailed replies provided in the list of issues. My delegation is willing to provide any further clarification that the members of the committee may wish to raise. Thank you.
Thank you, Mr. Agius. Okay, we're running close on 20 minutes behind now. Let's see how things develop. But I would encourage colleagues as well as the delegation in its later replies to our questions to be as succinct as possible. It's now the turn of colleagues to deal with the first cluster. The first cluster is going to concern issues 1 to 8 of the list of issues. That's a constitutional and legal framework and non-discrimination. And I have a list of speakers on these issues. The first is Mr. Flinterman. Mr. Flinterman, you have the floor.
Thank you, Mr. Chair. And first of all, I would like to join you in most warmly welcoming the delegation of Malta. It's indeed a long time since 1993 that our committee met with a delegation from Malta. And at that time, our committee was very modest in adopting recommendations and suggestions to the State Party, which was before the committee. In total, 4 recommendations were made. And I'm very pleased that to note here that at least one of those recommendations has been implemented over the past 20 years. And that is that the committee at the time expressed its hope that the government of Malta will consider the ratification of the second optional protocol to the covenant, which is dealing with the abolition of the death penalty. At the time, it did so with a reservation, but fortunately that reservation has been withdrawn in 2000. But yet, I was somewhat surprised to read paragraph 77 of your report, in which the government is addressing the issue of the death penalty, because there the instruments which are relevant in the field of the death penalty have been enumerated, but there is no mention whatsoever of the second optional protocol to the covenant. That must have been an oversight. I would like to thank you, Mr. Head of Delegation, very much for the very detailed report, which gives the impression of an initial report, and I think that's certainly helpful given the time lapse. And it's clear from the report, from the replies to the list of issues, from your very informative opening statement, that a large number of positive developments have taken place in Malta. But it will not surprise you that a number of concerns remain. Concerns also particularly in those areas where the State Party only succinctly indicates that its position, I quote, that its position remains unchanged, and end of quotation, or is using words of a similar nature. And therefore, I'm so pleased, Mr. Chair, that today we have the delegation of Malta with us, which could provide, hopefully, further arguments for such unchanged positions, and which will be able to answer our further queries and questions. And I'm very happy indeed that the delegation has agreed with a somewhat different structure of our dialogue. And that brings me to issue number 1, that is the issue relating to the status of the covenant in the legal order of Malta. In 1993, that was the principal concern of the committee. In paragraph 7, the committee made the point that the covenant, unlike the European Convention on Human Rights, is not incorporated into the domestic legal system, and that there is no clarity of whether the covenant prevails over conflicting domestic law. And in paragraph 9, the committee at the time made a point that it seemed that preference was given to the European Convention on Human Rights and Fundamental Freedoms in domestic law and legal doctrine, despite the point that was made by the committee that, at the time that there are important differences between the European Convention on Human Rights and the Covenant on Civil and Political Rights. From the very short reply to issue number 1, it seems that the situation has not changed in Malta. The response does not give any indication, for example, of any court decisions in which the provisions of the Covenant on Civil and Political Rights has been invoked. And it's only in paragraph 453 of your report that the information is given that the substantial rights under the Covenant on Civil and Political Rights are not directly enforceable. And what struck me further, Mr. Head of Delegation, was that Malta has ratified the optional protocol to the Covenant, accepting the mandate of the Human Rights Committee to examine individual communications, individual complaints. But since 1991, no complaint, no case has ever been submitted to the Human Rights Committee. And my question is to you, Mr. Head of Delegation, why is that? Are lawyers unaware? Is the judiciary unaware of the provisions in the Covenant? Or maybe most importantly, are rights holders themselves, the individuals, citizens of Malta and others living within the jurisdiction of Malta, not aware of their rights under the Covenant? And I would very much appreciate if the delegation could comment on my reflections. And I have a concrete question in this respect, and that is whether there is a legal procedure in place in Malta which can be used to implement the binding legal decisions of the European Court of Human Rights. And I'm asking that because if that's the case, my question would be whether that procedure could also be used for the implementation of views by the Human Rights Committee relating to Malta, if ever such views would be adopted. And that brings me to issue number 2, Mr. Chair, and that's the issue of reservations. It was touched upon by the Head of Delegation in his opening statement, and I was very pleased to hear that it is the policy of the Maltese government to periodically review its reservations to international human rights instruments with a view to withdrawing them. Well, at the time of its ratification of the Covenant, Malta submitted 6 reservations to the Articles 13, 14 paragraph 2, 14 paragraph 6, 19, 20 and 22. And our committee in 1993 already stated that those reservations have an adverse effect on the effective implementation of the Covenant, end of quotation. And further on, and again a quotation, that no convincing reasons had been offered for the reservations to Article 13 and Article 14, paragraph 6. And further, another quotation that given the actual situation, I'm talking about 1993, the actual situation of human rights protection in Malta, some reservations may now have become obsolete. That was 1993. And the Human Rights Committee asked then the state party to review its reservations. And now we are 21 years later. We read the report, we read the replies to the list of issues, and we listen very carefully. And I had the expectation and hope that today we would hear something else. But no, the indication is given that Malta will maintain its reservations without any further explanation given. And for that reason, Mr. Chair, I do hope that the delegation is willing and able to give those reasons today. And let me have a look at each of the reservations. I think it's important to do that. Well, first of all, the reservation to Article 13 on the expulsion of aliens and Article 14.2 and 14.6, I think, and I submit that to the delegation, have become obsolete in light of the ratification by Malta of Protocol 4 and Protocol 7 to the European Convention on Human Rights and Fundamental Freedoms without reservations to protocols dealing with the same substance at Article 13 and Article 14. My question is, could the delegation comment on that? The reservation to Article 20 reads that Malta reserves the right not to introduce any legislation for the purpose of Article 20. But yet, paragraph 455 of the report informs us that such legislation prohibiting incitement to racial hatred has been recently adopted. And it seems to me that by that information, the basis for maintaining the reservation to Article 20 has fallen away, has fallen apart. The reservation to Article 22 reads that the government of Malta reserves the right not to apply Article 22 on the freedom of association to the extent that existing legislative measures may not be fully compatible with this article. That was 1991. And my question is, what were those existing legislative measures at the time? Have they been amended in the meantime? Are they still relevant? And then finally, the reservation to Article 19, that crucial article on the freedom of expression and opinion, cornerstone of every democratic society. I would like to invite the delegation to explain why those reservations, there are two reservations to Article 19, relating to limitations of freedom of expression for civil servants and the freedom of expression of aliens, are still important in 2014. And in that respect, I would like to invite the delegation to also have a look at General Comment number 34, adopted a few years by our committee, which is focusing on the relevance of Article 19 of the freedoms of expression. And I'm saying this, Mr. Chair, because I take it that the delegation would fully agree with me that the statement made at the World Conference on Human Rights of 1993, in which all member states of the United Nations were in consensus about the call of withdrawing reservations, that statement is still valid today, that we should strive for a world in which all international human rights instruments are ratified and accepted without reservations by all states around the world. And that brings me to issue number 3, and that's the National Human Rights Institute. And I was very pleased to read and to hear today that Malta is moving towards the establishment of such a national human rights instrument. I found it very interesting to see that as an immediate reaction to the latest examination of Malta in the context of the Universal Periodic Review, the government of Malta is now taking steps towards the establishment of such a National Human Rights Institute. And indeed, the relevance of such a National Human Rights Institute as a link between the international and domestic system of protection and promotion of human rights cannot be underestimated. And I was pleased to read that the present proposal in Malta follows the example of my own country, the Netherlands, in making the Equality Commission into a National Human Rights Institute. It struck me, I read the report of your parliamentary ombudsman, who claimed that was his main conclusion, that the parliamentary ombudsman would be the ideal National Human Rights Institute. And of course, it's not up to the Human Rights Committee to decide what would be best. For the Human Rights Committee, it's important to know that a National Human Rights Institute to be established fully fulfills the conditions of the Paris Principles. But it would be interesting, I would like to invite you to do that, to indicate what how the new National Institute of Human Rights and the Parliamentary Ombudsman will work together for the promotion and protection of human rights and fundamental freedoms in the context of Malta. Thank you very much, Mr. Chair.
And thank you, Mr. Flinterman. The next speaker on my list is Ms. Vatterfall. Ms. Vatterfall, you have the floor.
Thank you, Mr. Chair. Let me also warmly welcome this delegation of Malta. I'm going to ask questions on issue number 4 and 5. We are very pleased with the amendment of Chapter 456 of the Laws of Malta, Equality of Man and Women Act, to safeguard equal treatment on additional grounds, including religion and belief. We also welcome the enactment of Bill number 18 into law, aimed at amending the anti-discrimination provision in the Constitution by adding sexual orientation to the list of prohibited grounds. I would like to ask the delegation to explain why language is not included in the prohibited grounds to the anti-discrimination provision. Reading through the national report, in analyzing Article 2, where you give the definition of discrimination, I also didn't find language as a prohibited ground. So would you please explain to us why language is not included? I also tried to look at the analysis of Article 27 in your report, but I missed that. So maybe you can explain why you didn't analyze Article 27 in your report. With regard to issue number 5, for the record, I will repeat the question. Please indicate how the provisions of the law, Article 9 of the Criminal Injuries Compensation Scheme Regulations, Legal Notice 186 of 2012, which provide that the only victim of crime who may apply for compensation before a criminal court are Maltese, European Union nationals, or habitual residents of Malta, how that is consistent with the non-discrimination principle of the state party's obligation under Article 26 of the Covenant. And with that, Mr. Chair, I thank you, and I also thank the delegation in advance for their response. Thank you.
Thank you, Ms. Waterval. The next speaker on my list is Ms. Majadina. Ms. Majadina, you have the floor, ma'am.
Thank you, Mr. Chair. I'd like to join my colleagues in extending a warm welcome to the delegation from Malta. For a small island country like yours, I am impressed by the size of your delegation, especially as it covers quite a few government departments. So we are indeed happy that we'll be engaging with people who are bringing the expert knowledge we need from the various areas in government that you represent. My issues are number 6 and 8. On number 6, measures are taken to combat manifestations of racism and xenophobia. I must say Malta has made progress in this regard. When I look at the report itself as well as the written replies. For example, Malta has made amendments in the criminal code, or these amendments are shortly going to be operational. There's also training and education programs for police officers, especially those attending to border guard duties. Other measures include the passing of the first reading of Bill 53 of 2014 in Parliament. This also is a significant step forward for Malta, although it will take time, of course, for the bill to become law, as it has to go through, I'm sure, a number of stages before it is adopted. I have a few questions, though, in spite of the fact that I'm quite happy with the responses. First, can the delegation give us more details of the impact of training activities by the National Commission for the Promotion of Equality in combating racism and xenophobia? What kind of evaluation and monitoring methods are used to measure improvements in police handling of racial discrimination and racial violence? My second question relates to the National Commission for the Promotion of Equality. This commission seems to have a huge mandate, but I'll just ask about the number of investigations carried out so far by the National Commission into cases of discrimination in accessing housing and accommodation, discrimination in places of entertainment and public transport. This was not responded to in the replies, and I wish I could get more information, oral information from the delegation. In addition to investigations, could the delegation tell us what have been the findings, if any, of the investigations carried out? Have there been any sanctions for perpetrators of discrimination in these areas that I've identified? And then lastly, on issue 8, I'm wondering when the National Action Plan Against Racism will become operational. Are there any timelines that the delegation can give us? That then makes me go on to issue 8 on measures to enhance representation of women. Again, much progress has been made here by Malta. The representation of women in Parliament, as found in Annex 8, Table 2, shows an improvement in the number of women from 1993 to 2008. In Annex 8, Table 3, figures show that female lawyers make up 10.3% of total mayors in the country. Female deputy mayors comprise 16.2%, and so on. Female councillors, an even higher percentage. There's also been an increase in women who are working in senior positions in both the private sector and public sector. The figures are given, which I'm very grateful for. As of 2011, almost 30% of members of the judiciary are female, with the number having increased from 3 in 1997. So, indeed, this is quite encouraging information. But of course, I still have questions to ask. First of all, though the representation of women in Parliament has increased since 1993, when there was only one woman, and the number increased to 6 in 1998, it has remained there since then. And in other words, the number of women in Parliament is still outweighed 10 times by the number of men. Would the delegation care to comment on that? Several of the tables, which are very informative, do not provide current information, though. So can the delegation provide updated statistics of women in public and political life and in decision-making positions now in 2014? Thirdly, could the delegation describe how the National Council of Women is supported by government? It is an NGO, but it seems to have initiated quite a number of projects that can potentially further the representation of women in many areas of life in Malta. So I would like to understand more how government interacts with this very important body. The National Council for the Promotion of Equality receives and acts on complaints of discrimination. And so in view of the many legislative measures taken, such as, for example, the passing of the Employment and Training Services Act, what has been the trend in complaints of unequal treatment in the workplace by women? Are there equal salaries for equal work done by men and women in Malta? Are there any complaints of harassment in the workplace by women? And lastly, can the delegation describe the system of free childcare and how it operates? How has Malta measured the effect of this? Because that's the only response actually we get from the written replies. The other information is contained in the original report. So I'm wondering why this is highlighted. And so I'd like to know what impact free childcare has had on female participation within the labor market and public life. Are there any statistics? Then very, very lastly, does the protection of maternity regulations, do these regulations evolve in accordance with the plan that is stated in the initial report, now giving 18 weeks of uninterrupted maternity leave? Is this indeed the case in practice? I thank you very much, sir, for this initial round. I look forward to responses. Thank you.
Thank you, Ms. Majudina. And the final speaker on my list, Ms. Zaibert-Foh. Ms. Zaibert-Foh, you have the floor, ma'am.
Thank you, Mr. Chair. I would like to join my colleagues in warmly welcoming the distinguished delegation from Malta and in hoping for a constructive dialogue. I would like to address the protection of lesbian, gay, bisexual and transgender persons, especially in educational settings. That is issue number 7. We have taken due note of the 2014 constitutional amendment, which included sexual orientation and gender identity as grounds for non-discrimination, that was referred by the head of the delegation in his opening statement. However, there have been concerns about allegedly homophobic atmospheres in schools, including bullying and harassment of LGBT students in the country. I very much welcome the very elaborate answer to our question and the commitment which the state party expressed to promote tolerance in school. But I should also say that the answer given is rather general. It outlines general policies and objectives and points out that schools are encouraged to take steps. Therefore, I would like to hear more about specific steps taken by the government to combat bullying and harassment of LGBT students in educational settings, such as, for example, introducing teaching of tolerance to school curricula and the training of all teachers. There are concerns that teachers do not intervene sufficiently to forbid or to cease harassment due to a lack of clear policies and training. Are sexual orientation and gender identity part of the school curriculum in the state party? How many instances of bullying and harassment have been recorded? With respect to transgender students, concerns have been expressed because secondary schools are usually sex-separated. Is it right that transgender minors are denied access to public schools because of a refusal to recognize their gender if it's different from birth before sexual reassignment surgery? The state party's replies refer to the opening of co-educational schools. So I would like to know how many co-education schools are there in secondary education and what is the percentage and do they exist throughout the island? Thank you.
Thank you very, very much, Ms. Zaibert-Foh. Okay, and this is the point at which I now immediately return the floor to the delegation. I'll allow it a few moments just to organize who replies to what.
Well, first of all, I have to thank all delegations who have come forward with very interesting questions, which makes our exercise even more productive, I hope.
Forgive me for interrupting, Ambassador, but we're not delegations here. We're members, individual members of a committee, and it's something my colleagues are very sensitive about.
I thank you. I thank you for the clarification. So, by way of managing the questions, I refer to the first question concerning the status of the covenant. By way of reply at this stage, I wish to say that the principles of the covenant are enshrined in the Constitution of Malta, and obviously then they overspill into the criminal code and other instruments. Concerning the status, Malta will continue to uphold the fundamental values enshrined in the Universal Declaration of Human Rights and its subsequent covenants, including the ICCPR, as was mentioned. These values are deeply enshrined in the building blocks of Maltese society, starting in the Constitution, all the way to the various bodies apt for the protection and promotion of human rights in all their facets. Malta will do its utmost to further its implementation of human rights instruments and widen their reach, with a view to ensuring universal respect for and protection of human rights. Malta is party to various international covenants and has signed numerous conventions that bolster its position in protecting and promoting human rights. The Maltese government has, over the years, also taken various legislative initiatives aimed at further safeguarding the implementation of particular human rights by instituting new legislation addressing various human rights aspects. In addition, a number of specialized commissions, commissioners and authorities have been set up with specific mandates to protect vulnerable groups and guarantee the protection of their rights. These include, as was mentioned in various parts of the initial statements, National Commission for the Promotion of Equality, National Commission for Persons with Disability, the Commissioner for Children, National Employment Authority, and also the Commissioner for Voluntary Organizations. We have also taken note of the various parts of your question related to Article 13, 14, 20, 22 and 19. And we have also thought that it would be more productive if we consult each other on the responses we can provide within the forthcoming 48 hours, and if that is possible, we'll then provide them accordingly. Concerning your last question related to the human rights, new National Human Rights Institution, I'd rather give the word to the head of delegation, who is also responsible in this regard, and ask him to elaborate, if possible, on that issue.
So, when it comes to the National Human Rights Institution, we're looking at the various models that exist. We're taking our time to study them, and also the reports from the Fundamental Rights Agency, taking on input from the Commissioner for Human Rights of the Council of Europe, amongst others. We have also, it so happens, consulted the Dutch National Human Rights Institution, and they have provided us with the bill in English, the law that actually set them up, and also other technical assistance already. In terms of how this new National Human Rights Institution will be working with the National Ombudsman, it is believed that this National Human Rights Institution will have a wide remit when it comes to human rights and equality, while the Ombudsman will retain its current role. Of course, working closely together will be key to the success of both. Another question was actually asked about the current work of the National Commission for the Promotion of Equality, and I will answer that also. NCPE will continue to raise awareness and disseminate information on rights and responsibilities related to equal treatment, to monitor the implementation of national policies with respect to equality, and to assist persons who are discriminated against by investigating their complaints. The stemming of the development of racism and xenophobia is an ongoing process through training and awareness raising. It is envisaged that the efforts will be strengthening in context of the widening of the NCPE remit, which I'm referring to as the National Human Rights Institution. NCPE provides training on racism and xenophobia on request to various groups of stakeholders to disseminate further information on the rights and responsibilities related to racial equality. Training sessions are tailored according to the needs of the respective group, including migrants, varying in time, structure, and media used. Moreover, NCP has carried out research to develop a national action plan against racism and xenophobia, on which it is working on an ongoing basis in order to strengthen its efforts in the field.
Concerning the second question by Ms. Vattenfall, I do apologize if we pronounce the names not correctly, but it's what went on through our system. You referred to, inter alia, questions related to sexual orientation to the list of prohibitive grounds, and also why language is not included as a prohibitive ground. I once again give the word to the head of the delegation.
So we thank you all for the fact that you're highlighting the inclusion of sexual orientation and gender identity as a key step forward. We believe that it is indeed such a case, not least because it was included in the Constitution of Malta. Both grounds were included in the Constitution of Malta. When it comes to language, or for that matter, other grounds, we will consider recommendations made to us, also in view of the change in institutional setup that will be setting up the National Human Rights Institution that I referred to earlier. So thank you for that. For the time being, I can't comment one way or the other, though.
The third set of questions came forward from Ms. Majedini, and inter alia amongst the questions was one that dealt with the training of police officers, which I will be giving the word to the expert coming from the Ministry of Home Affairs. There was also questions related to the National Commission on Equality and whether investigations were carried out in this concern, National Action Plan on Racism. Also mention was made about the enhancement of representation of women in politics, and it was commented that there was a general increase from the last report, and this we welcomed very positively. The increase of women in Parliament, an update on women in public life and whether there are statistics to corroborate this, the National Council of Women and whether it's supported by government, National Council on Equality again, and does the protection of maternity regulation in terms of the number of weeks for maternity, is this in practice, and to what extent we have gone forward on this? So, as to the first part of the question, I give the word to our expert from the Ministry of Home Affairs to touch upon the training of police officers in.
As part of training that is provided to police, including new recruits, there is training on several different provisions of the criminal code, including provisions against racism and xenophobia, as well as anti-discrimination issues. The issue of detention is, of course, separate from the police. Detention officers are also trained, in fact. However, they follow a separate course of training from the police, focusing on issues relevant to detention, including avoiding using coercive force whenever possible, and such like. But basically, to answer your question, training within the police academy does address issues of anti-discrimination, racism, and xenophobia.
Other questions specifically related with the set of questions put forward by Ms. Majedini also included enhancement of representation of women in politics, and also the National Council of Women and how are these supported by government. I give the word also from the ministry concerned in order to elaborate on these two.
Thank you. NCP is currently working on various initiatives with the aim of increasing the number of women in decision-making positions, empowering and enabling women to take up decision-making positions, and at supporting and advising policymakers on gender balance in decision-making, namely a mentoring program for women, the compilation of the Directory of Maltese and Gossiping Professional Women, and 2 research studies on gender balance representation in decision-making and on gender quotas and other measures.
Thank you.
When it comes to NGOs, we would not highlight one NGO over another. In fact, for us, all NGOs working in the field are highly important. Our ministry, the Ministry for Social Dialogue, has set up a system of consultation with civil society, formal consultation in several meetings, as well as also we have launched a public consultation system on all bills presented in Parliament that civil society can contribute towards. We also have a system of supporting NGOs, both financially and in other means, through other means. But once again, we would not highlight one particular group over any other. We relate to all of them in the same way.
Finally, in question 4 by Ms. Zaibet, mention was made of the protection of gays in the educational setting, and also mention was made about the alleged homophobic and combating bullying, and the teaching of tolerance in schools, policy and training in this regard, and the percentage of co-education of schools currently in Malta. So, in this regard, I once again give the word to the head of delegation, and following which we'll also ask our expert from the Ministry of Education and Employment to also throw light on the issue of bullying and co-education. Thank you.
Malta is particularly pleased with the way it has developed this area. For us, it's one of those things where we believe that we've made a huge turnaround, and we've managed to bring LGBTI issues way up on the national stage, as well as the international stage. On the national stage, we have set up the LGBTI Consultative Council, which is a body consisting of all the NGOs working in the field of LGBTI rights without exclusion, as well as LGBTI experts. This body is the body that develops laws respective to the LGBTI community and actually presents them to the minister responsible for equality. We believe that that practice is in itself a good practice to share with others. We have also taken other initiatives. For example, earlier this year, Malta hosted the Idaho Conference, which was first launched in The Hague the year prior, and we hosted that with Sweden jointly. During that conference, a declaration of intent co-authored by Malta and Sweden was launched and was subscribed to by 17 states from all of Europe. So we believe that we're actually moving on this matter at very big steps. This also has been recognized by European level civil society. My minister, Minister Helena Dalli, was invited to 2 international conferences dealing with the matter. She was a keynote speaker to Transgender Europe earlier this year in a conference held in Budapest, as well as a panel speaker of the first panel of the conference that just ended over the weekend, held in Riga and organized by the European region of the International Lesbian, Gay, Bisexual, Trans and Intersex Association. I'm saying all this because we believe that as a country that has, in the past year and a half, placed this matter high on the national agenda, we've made tremendous progress in this field. I will now pass on to my colleague from the Ministry of Education, who also has quite a number of initiatives to report.
Firstly, as regards to co-education, as of the academic year 2013-2014, in Malta we had the first co-ed school for secondary school age. It is to be noted that primary education is co-ed from the beginning. The only difference was that secondary was single-sex, and as of this year, all secondary schools are now being phased into co-ed educational settings. That would mean that by the academic year 2018-2019, all secondary schools in Malta, both middle school and secondary schools, will be co-ed. And that would facilitate our efforts that we are doing as regards trans students as well, since neutral gender bathrooms is now being discussed and will be implemented in the future as we speak. This also solves the problem of uniforms that we previously might have had, because the choice of uniform was a bit tied with a single-sex schooling, and now the option is more available. As regards curriculum, it is also with pleasure to note that we are dealing with curriculum on two strands. The first strand is that we just last week launched a Respect for All framework, which highlights the need for values-based education throughout all the subjects taught in schools. However, in parallel to it, and to promote tolerance and respect in the different subjects, there's a subject personal social career development which specifically deals with sexual orientations and the different relationships. And that would help the students discuss. Further to that, students would be encouraged, if they have any difficulties, to either discuss them with their teachers or the professional services offered in all schools in Malta, both primary and secondary, which would be guidance teachers and counselors, who would then be able to follow up with the necessary help that they would need. Statistics about the bullying incidents will be reported later.
Concerning the question relating to investigations on the NCPE and the updating of tables, we will be doing our effort to provide an answer within 48 hours.
Thank you very much, delegation. I now turn back to colleagues to see if there are any follow-up questions to the replies we've received from the delegation. Mr. Flinterman, you have the floor.
Thank you, Mr. Chair. And I would like to thank the delegation for the responses given so far. I must say I'm looking forward to the further information that was promised by Mr. Ambassador on the reasons why the Republic of Malta deems it still important to maintain its reservations, 6 reservations to the Covenant. In our general comment number 24, the committee has indicated on the issue of reservations that in the framework of the constructive dialogue, it will always address reservations made by states parties, just to be informed about the reasons for maintaining such reservations, and also to discuss whether the basis for such reservations is still relevant, all with a view to see to it that states parties withdraw reservations which are not necessary anymore. And for that reason, Mr. Chair, I do hope that although the promise has been made to send us the information within 48 hours, that if possible, and in the light of the comments made by the head of delegation in his introductory statement that reservations are periodically reviewed with a view to withdrawing them, that hopefully the information is readily available in Malta, and that maybe in the course of tomorrow morning's proceedings, it would be possible to have a somewhat further discussion, informed discussion, in the presence of the delegation. If that would be possible, and that would be my plea to the delegation, I take it also my colleagues in the committee would very much appreciate that. That's one. And secondly, on the issue of the status of the covenant in the domestic legal order of Malta, I don't like to be misunderstood. I'm not doubting in any way whatsoever the commitment of the Republic of Malta to uphold the substance of the human rights enshrined in the covenant. But my question is, and maybe I can put it in simpler terms, reading the report, and I made that note about the oversight of the ratification of the second optional protocol. I also made the point of the non-reference to the first optional protocol, to the lack of cases from Malta before the Human Rights Committee in the framework of the optional protocol. Reading the report, my question is, how visible is the Covenant on Civil and Political Rights in the context of the domestic legal system, both the legal system and the practices of every day in the context of Malta? And maybe I could invite the delegation to comment on that a little bit further, or to reflect on that a little bit further, because we have been informed that as to the European Convention on Human Rights and Fundamental Freedoms, there's a specific act, and of course that makes that convention visible. A similar act does not exist for the Covenant on Civil and Political Rights, and maybe it's not necessary. But my question is my impression correct that the Covenant on Civil and Political Rights in the context of Malta is rather invisible, let me phrase it in those terms. And I would like to invite the delegation, Mr. Chair, through you, to reflect on that.
Thank you very much, Mr. Flinterman. Are any other colleagues wanting to pose? Ms. I couldn't see the hand. Thank you. Ms. Majidin, you have the floor.
Thank you. I just wonder, maybe I missed the response here, but I did ask for updated statistics on the representation of women in public and private life. I did read what was in the tables supplied in the replies, but these are a bit outdated, so I wondered whether there's any new information. I didn't hear anything in this regard. Thank you.
Thank you, Ms. Majodina. Ms. Waterfall, you have the floor.
Thank you, Mr. Chair. I also thank the delegation for the answer, but I still miss the response on issue number 5. Maybe they have forgotten me. I don't know. Thank you.
That's the limitations on access to criminal injuries compensation. Any more follow-up questions? No further follow-up questions. Again, I'll invite the delegation to respond now. Obviously, with certain information, my guess is the delegation may wish to seek the details from the capital. One possibility also is that if information is available tomorrow that isn't available today, then we'll find a way of feeding that too into our deliberations. So back to the delegation now to see what response it is able to give to the follow-up questions that have been made by colleagues. Delegation.
Thank you for the further questions that were posed forward. Of course, your understanding would be more than welcome in the context of positions that we have concerning line ministries and as they are provided. But we'll try to make a further attempt to at least two of the questions that were put forward. One by Ms. Van der Waal concerning issue number 5, concerning limitations. And I give the word to our expert from the Ministry of the Interior to give a provisional response. Thank you.
Sorry, I can give only a provisional response for the time being. However, the Criminal Injuries Compensation Scheme regulations were actually intended to transpose into Maltese legislation an EU directive, Council Directive 2004/80 EC, which they have, of course, done. We consider it is debatable whether this particular scheme falls within the ambit of Article 26 of the ICCPR, given that here Article 26 refers to equality of persons before the law without discrimination. Of course, anti-discrimination is covered in other parts of the legislation and not in this one. So we consider it debatable whether this falls within the ambit of Article 26. Thank you.
Concerning the question by Ms. Maghedini related to the updated statistics of women in public life, we will try to do our best to get an update on this as soon as possible. Thank you. I wish to address the issue concerning the visibility of the covenant. The covenant is available for the public by means of the usual systems in place. So if your question is whether there are initiatives to further make it visible, that obviously is an issue which the delegation will take note of and will report back also to Capital in the context of the views expressed that this could be welcome. And I'm sure that if government feels that this is possible, efforts in this regard will be made.
Fine. Thank you very much, delegation. I just note at this stage from the chair in respect of the provisional response in relation to issue number 5 that I'm glad to hear that it is provisional and would hope that a little bit of further thinking might go into the final answer from the perspective of this committee. Article 26 does not confine itself to nationals and habitual residents. It doesn't confine itself to equality either in relation to one particular region. Anybody who, in this particular case, is a victim of crime would seem to be being discriminated against within the clear words of Article 26 if the mere fact that they're not nationals or habitual residents were to disqualify them from compensation. But it would be interesting to hear what understanding of Article 26 the delegation has. Maybe we've missed something in the preparatory material, but the practice of this committee and the previous understanding of the committee in its general comments relating to non-discrimination, including in Article 26, would not see those as grounds for discrimination. With that, the first cluster is the discussion. The first cluster is terminated. Already, I'm very grateful to the delegation for the way it has coped with this process so far. I suspect I'm going to be saying that more than once between now and lunchtime tomorrow. We now move to the second cluster. That's to say the issues relating to violence against women and children, including domestic violence, that's issue 9, and right to life, prohibition of torture and cruel, inhuman or degrading treatment, right to liberty and security security and the treatment of persons deprived of their liberty, including conditions of detention, rights of migrants, refugees, and asylum seekers. That's issues 9. That's issues 10 to 16. So altogether, the cluster consists of issues 9 to 16. And I immediately turn to colleagues to pose their follow-up questions to the distinguished delegation in reaction to the written replies that we have received. The first speaker on my list is Ms. Vatafal. Ms. Vatafal, you have the floor, ma'am.
Thank you, Mr. Chair. I'm going to address issue number 9 regarding violence against women and children. And we are pleased with all the measures you have taken to address violence against women, including sexual and domestic violence, and child abuse, including child sexual abuse. If I turn to paragraph 40 of your replies, you stated that there are women's shelter available. Can you provide us with the number of shelters you have for the victims of domestic violence and other kind of violence? In paragraph 41, the last part of the first sentence, you said, and also organizes men's services for perpetrators of domestic violence. What do you mean by that? Do you mean programs for perpetrators to change their violent behavior? Maybe you can elaborate more on that issue. Also, turning to the Annex 1 on the table, where you have given us some statistics on figures on domestic violence. I'm a bit puzzled. If I look at table number 1A, and you talk about new cases opened at the domestic violence unit in the year and so on, then I see that for, and you have given us 5 years, for rape, there is 0. For neglect and sexual, 0. For prostitution, there is 0. I don't know. Maybe you can explain to us, or are these violence acts also included in the emotional and physical violence? Turning to child abuse, including child sexual abuse, in table number 2, for child abuse and child neglect in 2014, okay, there are already 10 months, there are 0 investigations. The violence against women, including sexual and domestic violence, also in table number 2, we see that for sexual harassment, for 2013 and 14, there are also 0 cases. Maybe you can elaborate more on these tables you have provided us. And also, I'd like to have some answer on the effectiveness of the measures to protect women and children against violence. How effective are these measures, and the impact, of course, of the measures you have taken? And with that, Mr. Chair, I thank you, and I also thank the delegation in advance for their responses. Thank you.
Thank you, Ms. Vatafal. The next speaker on my list is Ms. Zybert-Foh. Ms. Zybert-Foh, you have the floor.
Thank you, Mr. Chair. I would now like to turn to the right to life and would ask the distinguished delegation to address issues number 10 and 11 in a little bit more detail. I'm concerned about reports of excessive use of force in immigration detention centers. We have learned that there were protests and riots in the last years, which presumably resulted from the conditions of detention. My colleagues will come back to the conditions and the length of detention later. What I would like to know more about are the disciplinary and criminal measures taken in response to the use of force by state officials. We ask in the list of issues about the disturbance which occurred on the 16th of August 2011 at Safi Barracks Detention Center. But I'm missing an answer with respect to the specific event. We have received information that allegedly excessive use of force was resorted to with the use of tear gas and rubber pellets during this disturbance, that some detainees had been punched, kicked, and struck with truncheons, mainly by soldiers, after having been handcuffed. This was objected to by the state party, but the CPT, the European Committee for the Prevention of Torture, observed visible injuries during its visit, which were consistent with the allegation of ill treatment. My questions, therefore, are: how can the use of rubber pellets be justified under the ICCPR? What criminal proceedings against state officials have been opened in connection with these incidents? The replies refer to the inquiry into the death of a Nigerian immigrant whose name was Ifeanyi Nwokoye at Lister Detention Center after he fled and was recaptured. Could you please specify which criminal or disciplinary action was taken against personnel involved in the incident as suggested by the Board of Inquiry? Could you please provide us with some details of the findings of this inquiry? I would also like to hear which criminal action was taken in response to the death of the Malayan migrant Mamadou Kamara, who also died after his apprehension on 30 June 2012, allegedly beaten to death by guards at the Safi Detention Center. What is the outcome of the charges brought against two soldiers who were allegedly responsible for the death? The replies refer only to disciplinary action. I would also like to know about the results of the investigation and whether these results were made public. Could the distinguished delegation also please inform us about a disturbance which occurred in the Lister Barracks Detention Center only in February 2014, which allegedly resulted in some injuries too? What is the result of the inquiry into what happened then? And finally, more generally with respect to issue number 10, I would like to know what are the disciplinary rules in detention? Is there a mechanism in place for the systematic review of the conduct of detention service personnel? So far with respect to issue number 10. Turning now to abortion, issue number 11, I have noted that under Maltese law, abortion is generally considered a crime. According to the state report, abortion is considered a crime and illegal in all cases. Articles 241 and 243 of the Criminal Code provide for criminal punishment of the medical staff as well as for the woman seeking abortion. There is no exception when the life or the health of the mother is at risk. This was affirmed by the head of the delegation, who said in his opening statement that the determination of pregnancy through abortion, for whatever reasons, is in violation of the right to life and that therefore cannot be recognized. How can this be reconciled with the protection of the right to life of the mother under the covenant? I would like to know. How can the prohibition of abortion in pregnancies resulting from rape or incest be reconciled with the prohibition of cruel and inhuman treatment under Article 7 of the International Covenant on Civil and Political Rights? Considering these circumstances, does the state party consider providing for exceptions to this general prohibition of abortion? I would also appreciate if the distinguished delegation could explain which measures are in place aimed at the prevention of unwanted pregnancies by inter alia making a comprehensive range of contraceptives widely available to an affordable price. I'm afraid that it is not sufficient to recognize the importance of dissemination of knowledge and information on safe and effective methods of family planning, but to take active steps. What steps does the state party take to prevent teenage pregnancies? The Committee of the Right of the Child has expressed concern about women and girls who seek risky illegal abortions. Could you please provide us with data on the number of complications resulting from illegal abortions and which steps have been taken to protect the lives and the health of women seeking clandestine abortion? Thank you, Mr. Chair.
Thank you very much, Ms. Zaibet-Four. The next speaker on my list is Ms. Majardina. Ms. Majardina.